See, bionic hand. This is a great invention. There are so many inventions which are patented and successfully commercialized. See, Coca-Cola can. The functional aspect of this can have huge commercial viability, and that's why it's successfully commercialized. The inventor obtained around 1.5 lakh UK pound a day as a royalties. Facebook about WhatsApp for $19 billion. So the objective of patent law is to promote the progress of science and technology. Further, to encourage inventors, the person who put their efforts and resources in invention, something that can be patented. So there must be some provision which helps such person like inventor to stop others, not to make copy without his consent. There are certain rights under Section 48 of Patent Act, rights of patenting inventions. The case where patented invention is a product, act of making, using, offering for sale, selling, importing for those purposes that product, and where the patented invention is a process, act of using that process, and from the act of using, offering for sale, selling, importing for those purposes, the product obtained directly by that process. So with a patent registration, the person may able to attract investment, do licensing in order to earn royalties. They may sell the patent to other person, keep competitors side, build the brand, and so the business, and take business from local to global. Many times we notice news regarding infringement of others' patent. So here Facebook Oculus told to pay $500 million for a stolen tape, that is of the software from Journey Max. Subject matter of patent is invention, आविष्कार. So सभी आविष्कार को पेटेंट नहीं मिलता. Only those inventions who fulfill certain criteria called patentability criteria may be considered for patent. Inventions की definition patent act में दी हुई है as per section 21J. It means a new product or process involving an inventive step and capable of industrial application. So it means invention is a new product or process and it involves non-obviousness and it has a utility. So all these three aspects of the invention as defined under the Act are used as a criteria to get a patent. Further, all these three aspects are defined in the Act. Novelty defined under section 21L. It means any invention or technology which has not been anticipated by publication in any document or used in the country or elsewhere in the world before the date of filing of patent application with complete specification. That is the subject matter not fallen in public domain. Means invention is new only if it has not been disclosed in the prior art. So what are prior art? Anything that has been published, presented or otherwise disclosed to the public before the date of filing of complete specification. So कोई भी चीज जो पब्लिक डोमेन में आ गई है, प्रेजेंट हो गई है, डिस्कस हो गई है, पब्लिश हो चुकी है, ऐसी कोई भी चीज इसकी नोवेल्टी नहीं मानी जाती. तो पेटेंट अप्लाई करना होता है बिफोर सच पब्लिकेशंस, बिफोर सच डिस्क्लोज टू द पब्लिक. Dr. R.A. Marcelkar, ex-Director General of CSIR, told, "Publish and patent is patent and prosper." जब आप publish करते हो, तो there is a possibility to get it Paris because you can't regulate the market. Anyone interested may use such publication. But in case of patent, in spite of having published, no one can use it for commercial gain without the prior permission. And that's why there is a technology transfer, assignment, and royalties. By mean, the patentee may get prospered. Next is inventive step, which has been further defined under section 21JA. That means a feature of an invention that involves technical advance as compared to the existing knowledge or having economic significance or both, and that makes the invention not obvious to a person skilled in the art. That means किसी इन्वेंशन को पेटेंट होने के लिए उसमें क्या तो टेक्निकल एडवांसमेंट होना चाहिए या इकोनॉमिकल सिग्निफिकेंस, जिसे कॉस्ट इफेक्टिव, या दोनों सोने पे सुहागा. और वो इन्वेंशन must not be obvious. Obvious किसके लिए? फोसिटा, person having ordinary skill in the art, that is person in the same field. There are some inventions which are non-patentable and mentions under section 3 of the Patent Act what are not inventions. So the act itself declaring what some examples of non-patentable inventions. A method of treatment of human and animal, inventions that cause serious prejudice to human, animal, or plant life or health or to the environment, computer program or algorithm, mere discovery of a new form, mere admixture resulting in aggregation of properties, mental act or method of playing game, presentation of abstract ideas, inventions containing traditional knowledge, presentation of abstract ideas, inventions contrary to natural law, mathematical or business method, method of agriculture, inventions which fall under the Atomic Energy Act. So, such examples are either not the inventions, or even if considered inventions, they are not qualified for patent. You see, discovery is not the invention. Discovery is already present in the nature. And many things are as per the public policy. No patent is considered for such, like traditional knowledge. Again, this is in public domain and no one allowed to misappropriate it under the patent. This is the portal of Intellectual Property Office in India, where agent e-file the applications and anyone can search the status of applications or publications detail. Regarding jurisdiction of patent office in India, there are 4 offices: Mumbai, Delhi, Chennai, Calcutta. These are 4 metros of India. Regarding hierarchy of officers in patent office, there is a Controller General, the Chief of IP office in India. Generally, it's a IAS person under whom there are Joint Controller, Deputy Controller, Assistant Controller, and lastly, the Examiner of Patent. So for the sake of convenience, I divided the presentation in pre-filing requirement for patent and post-filing requirement for patent. Pre-filing, preferably the applicant suggested for signing an NDA, non-disclosure agreement, with the agent or with the expert to whom he is discussing his or her invention. Although NDA is not a requirement from the government side, so it's completely a desired option of the applicant or the inventor. Then patentability establishment that may be established by prior art search. Again, it's not a compulsory requirement, but it is suggested in order to save efforts, time, and the person may enable to understand whether the work may get patent or not, what are related publications or patent already in the public domain. Just